Next on TWiL, we've got the Darwin Awards of Criminal Law and Technology, how folks' tech is landing them in jail or otherwise making sure they go there when juries hear what their cell phones disclose about them. We're also going to disclose what very few people have seen, super secret national security letters that tell you not to tell anyone if you get one. We're going to talk about teachers and firings and all kinds of stuff with Erik Heels, Kevin Thompson, and Evan Brown next on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 99, recorded February 18th, 2011. Butt dialing to jail. Hi, folks. It's Denise Howell, and we're here for TWiL, episode 99. It's February 18, 2011, and we're thrilled that you've joined us. We've got a great show for you here today. We have all kinds of really fun and interesting things to talk about, but first, I want to welcome our panel. Welcoming back to the show, Kevin Thompson from Davis McGrath in Chicago and Cyber Law Central, his excellent blog. Hi, Kevin.
Hi, Denise. Thanks for having me back. I much appreciate it.
It's great to see you. Also joining us for a return visit to TWiL is Erik Heels from the Clock Tower Law Group in Maynard, Massachusetts, our favorite MIT engineer turned lawyer. Hi, how you doing?
Hi, Denise. Thanks for having me again.
Great to see you again, Erik. And
Likewise.
Joining us again is Evan Brown from Chicago, Hinshaw and Culbertson, and InternetCases.com, his blog. Hi, Evan.
How's it going? It's great to be here. Thanks for having me.
Great to have you back. Wonderful to have Chicago once again so well represented on the show. And we've got Massachusetts and California. So we're kind of covering the country as well as we can.
Right on.
And also covering the country are, I had thrown in a story that I think, Evan, tell me if they triggered your coming up with the rest of these super fun sort of the Darwin Awards of Law and Technology. I'm going to start out the show with here. The one that I threw in had to do with a juror in California who was ordered by a judge to turn over his Facebook posts that he made during a trial. There was a conviction during a trial. It was a criminal trial involving gang members. And apparently the juror was just there posting away on Facebook, this evidence is so boring, this trial is just deadly dull, la, la, la. So that's the kind of thing that actually can result in a mistrial and overturn convictions. So the judge ordered him to turn those things over. And he'll face contempt if he doesn't actually comply. So that was just sort of one of those, oops, shouldn't be doing that if you're a juror. And also, I thought it was interesting that, we always are talking about stories on the show, episodes, incidents on this show where people are going after the actual service provider to get at the information. The judge here has contempt power over this juror, so there's no need to get Facebook involved in this. He can just compel the juror to give over the information that the judge is looking for. Any thoughts on this one, Kevin?
Well, I think it's the standard, be careful what you post online. Goodness, if you're going to be a juror these days, you got to be really careful because judges and all the people associated with the cases are certainly going to be looking to see what you do.
Yeah, I think this is the kind of thing that jurors are getting instructed about routinely these days, but, maybe it's an object lesson in how jurors might not listen very closely or really care too much about the jury instructions they receive, and they're not ready, willing, or able to give up the things that they do technologically just because they're sitting on a jury. Erik, what do you think?
Well, I think if you're on a jury, to second what Kevin said, it's pretty much do what the judge tells you to do, and don't do what he tells you not to do. So, yeah, the Darwin Awards, I think, is appropriate for this particular case. It seems to be an easy one.
Right. Evan, any thoughts about the judge going straight to the source of the information rather than going to the provider?
For sure, you got to listen to what the judge says and do what the judge tells you to do, and all of that. And it sounds like in this case, it's much more serious. I mean, this was a criminal trial. I know that we saw something from Detroit a few months ago where that juror posted something on, it was either on Facebook or Twitter, talking about her experience, and the judge made her write an essay or something like that. Do you remember that situation?
That one's actually escaping my mind, but what a good call on the judge's part.
And I think that was a civil case, and one of the defense attorney's sons actually found the information and brought it to his dad's attention, who then brought it to the court's attention. So, yeah, I mean, it's a general policy that you should do what the judge tells you, but there's a certain certain part of me who would think, well, do we always just want to follow policies because they are what they are? All the guy did here, or at least all this, short article that we have about it here, he just posted that the evidence was boring. Big deal. So
right.
I'm sure the evidence was very boring. Does that really mean that there was some grand, terrible miscarriage of justice here? I don't know. But, I guess we just got to listen to what the judges say and leave it at that.
Yeah, I think that's the kind of thing that can routinely result in a mistrial, though. I mean, if it's boring, that means the juror isn't engaged, isn't paying attention, isn't properly weighing what's going on. I don't know. You could argue about it in court, but at least that gives them a basis to talk about something. Kevin, you were going to say?
Oh, I was just going to say that in the IRC room, Socrates had a point about the fully informed jury concept.
Yeah, what is that?
Well, just that juries should be allowed to research things as needed. And in response to that, I would certainly point out that our jury system is set up such that if they do have a question, they have an avenue for that. They don't have to go to the internet. They go to the judge and say, look, we need more information on this point. Look, I don't understand this point. Tell me what this is. And, those things are already built into our jury system, and we don't have to have people going online and perhaps looking at the wrong information. I mean, the Lord knows, who knows what was actually out there on Wikipedia. So somebody could have posted something that was actually incorrect. And so that's why people should actually be following the right procedure and doing what the judge tells them to do. And when they've got a question, they bring it to the judge.
Yeah, this guy would have been out of luck, though. What are you going to do? Go to the judge and say, Judge, I'm bored to death. Can we have the lawyer spice things up a bit? I don't know.
Right.
Not too much they can do. Okay, so we have some more Darwin Awards of legal technology over there in the UK, where people use the word nutter to refer to you're a bit off your rocker or crazy. There was a gentleman texting back and forth, and I don't know if you could really call either of these folks gentlemen, given what ultimately happened. But they're having a text message exchange, and the autocorrect feature on one of their phones changed mutter with an M in one of their messages to nutter, causing the other one to take grave offense. And things sort of went south from there. The first guy shows up at the second guy's house, and a stabbing ensues because he's so incensed at having been called a nutter. Evan, you tossed this one to us. There's no indication what phone or what autocorrect changed mutter from nutter, because mutter seems like a perfectly valid use of the language that doesn't require an autocorrect. How about this one? Not too much. This is maybe not a Darwin Award so much as, poor guy, nobody pays too close attention to these autocorrect things. We've all been bitten by them.
Right. I have a feeling that these guys could have used some therapy long before, this act of violence went down. There has to be so much more to it than just getting mad being called a nutter instead of a mutter. And the interesting thing is that the guy who did the killing is the one who called the guy the bad name. It wasn't that he got so mad for being called that, and then he ended up killing the guy. So there was just clearly some bad stuff going on, right? In the whole context for all this. And I sent in to you this story, and then there were a couple of other stories. It was so strange. Just one day this week, I think it was Wednesday maybe, I was reading my news feeds. And, I saw 3 different stories that really had a certain theme about them. One was this one.
Oh, yeah, no, we're going to talk about them all.
Yeah, right. And so, I mean, the theme being, and we'll drill down and get into some detail about these, is just, it's so wacky how mobile communications can really kind of catch up on you and take you by surprise and fill in a certain niche of your life that you didn't know was there. So if you're going to be doing bad stuff, if you're carrying a cell phone or going to be sending text messages, you got to be a little more. My new favorite word is vigilant. Cross between vigilant.
That sounds like a Bush-ism. Is that one you coined yourself?
No, it's actually I thank Doug Hofstadter. I've been reading a lot of his stuff lately, and he gave a great talk that I was watching on YouTube the other night about analogies and consciousness and language and all that stuff. And so it's interesting how people can mix up words, and you can often get a real meaning out of it. But I just really love that one because it seems to have such a clear import to it. So I'm trying to use that as much as I can.
Mm-hmm. So, Kevin, you think obviously, I guess the lesson from this one is if you're the kind of person who wanders around packing a knife and your friends do too, you should pay special attention to autocorrect. Any other thoughts?
Maybe next time get a phone with better autocorrect features. Good Lord. I mean, if you're going to be fighting over that, Evan's right. Obviously there's something else going on here. Perhaps this is just the final straw in an ongoing dispute between these two. Who knows, really? But all this is merely what started the fight. But good Lord.
Kind of straw that broke the camel's back, no doubt. Erik, any final ruminations on this bit of entertainment?
Well, I think this is another good example of where those that are predisposed to demonizing technology are just going to use this as another example, like to say, see, cell phones and technology are evil, and this is an example of the bad things that can occur. And I would argue that technology and the internet are they just are, and they can be used for good or for evil. So, but people like to believe what they like to believe.
No, there was a little homunculus in that predictive text really screwing with that guy's life. I have a feeling that he saw mutter and wanted to make it nutter. There was some intent there. It was that evil technology.
Maybe it's Watson. maybe he's moved. It has moved on from Jeopardy to subtly manipulating people's cell phone texts.
Yes.
Who knows? Okay, so further along these lines, there are a couple of more of these where the text messaging or other mobile communication means wound up as evidence in the case. Let's see. Here, I think this one was in Florida, Evan. Lots of funny things happen in Florida.
Yes.
This
sure.
There was a jilted boyfriend, I believe he was, being broken up with, who in a heat of passion decided to off his girlfriend who was breaking up with him. But to cover his tracks, he made off with her cell phone. It was never recovered after the killing, and then sent a text message to a mutual friend of theirs after she was already no longer with us. I guess trying to indicate, change the time of death, or I can't really fathom what the reasoning would have been, but he used her phone to send a text message and used an acronym in the text, GTG, good to go, which the mutual friend, I guess, discerned that this is something that the guy used, but not the girl. And so it's not real clear from the story, but I think that must have been, how people were tipped off, or at least it was evidence in the trial that that the killer had actually done this crime. Evan, what do you think of this one?
Yeah, this one happened in Syracuse, New York. There's that other story that we'll talk about. There's plenty of that goes on in Florida for us to talk about. So we got one to there. Yeah, but this one was in New York. Yeah, this is interesting. And what happened here is, I guess the guy was confronted with this evidence and realized that things weren't looking as good for him, and he entered a guilty plea. So this didn't actually make it into anything at trial here. But wow, talk about a couple of layers of abstraction for the meaningfulness of this information here. In using it as evidence. It wasn't just, merely something forensic that came about from the text messaging, but it was the use of this particular nomenclature to really betray the guy, to say that it was him and not, his girlfriend. I mean, clearly he was just trying to obfuscate things and confuse investigators as to where this girl that he had just murdered might have been, or when she died, or whatever. So, the thing I thought was interesting about that was how much interpretation had to go into this. So much use of electronic evidence like this is just to place. Just very much based on the data itself. But this, you had to look at those layers of meanings and customs for how he was using this acronym. That's what I found intriguing.
Right. Just imagine being the friend and you get this creepy message and you go, wait a second, the girl doesn't use that, the guy does.
Right.
Kevin, any thoughts?
Well, I had two thoughts. First, one was I think I saw a similar thing in an episode of CSI once, and it didn't work for the person in that case either. But the other thing too is the major way that this was found out was through someone reading a text and getting a sense for somebody's personality merely through an online post. Or in this case, a text. And I think that's certainly something worth talking to. Well, so certainly a distinctive phrase, something that she would never use. But that's something like, here we are interacting online on Skype, and there's a lot of other people that I interact with only solely by Twitter. And, would they, get a feel for who I am and who the things that I can say and the things that only I would say, but merely by what I would say on Twitter or other social media. And I think it's a really interesting question today.
It is. It's a good reminder that these sort of shorthand communication forms that we get into if we use technology frequently are not necessarily what the rest of the world uses. And, you get so used to them, but they can be very identifying. Erik, what do you think?
It sort of reminds me about when I had shoulder surgery and I was under anesthesia and I'm telling jokes while I'm under anesthesia. I have no memory of the jokes that I was telling. And then afterwards, people told me the jokes that I was telling. And I said, well, I have no memory of that, but it certainly sounds like me.
Mm-hmm. Were they good jokes?
Oh, they're always good jokes.
Oh, right.
So I think it's just a matter of time before somebody, is able to successfully use the technology. I mean, the criminals are getting smarter, and this one is probably more smarter than the one in the first example. But it's just a matter of time before they actually fool somebody.
And I like what you said, Kevin, about getting to know someone's personality from this. And you use the example of Twitter. And one way that I have thought of Twitter for a long time, even way back in the early days, is I really picked up on someone's description of using Twitter as cultivating in yourself an ambient awareness of what's going on around you. But another real catch, or another term that resonated with me for describing this, is a certain gestalt. A certain image that appears about particular members in your social network that you can get from little pieces of information, tiny little pieces of information. You start to develop a certain image of someone over that time. And Denise, what you said, it is just three characters here. Here on Skype, we are communicating our gestalts, within millions and millions of bits. But this was just one where it was, just three characters. And so it really is fascinating. Yeah.
Convinced him to plead guilty, as you point out. All right. Well, I don't know if this criminal was necessarily very smart. And it's so, I have a real sort of inner conflict and having a smile on my face as I talk about all this murder and mayhem. But this gentleman appears to have butt dialed himself to jail, or to a life sentence in jail, no less, and almost the death sentence, because there was a lot of deliberation based on this voicemail that was left in the middle of a murder. And this was our Florida story. It's here at TampaBay.com. That apparently here was a person who was in the midst of stabbing his wife, and somehow or another his phone must have, they don't really go into the details of how this happened, but must have auto-dialed in the heat of the struggle or whatever, perhaps the last number that he had dialed, his wife. And nobody knew this right away, but apparently, I think it was her sister, yes, the victim's sister, checked the messages on her cell phone after the fact and found, much to her horror, that there was an audio recording of what was going on during the murder. So this all came into evidence in the trial as evidence of premeditation, because he was telling her during the process that he was about to kill her. She had just confessed to having cheated on him. So heat of passion, but thanks to his phone, it all got recorded and came into evidence, and was a big factor as the prosecution was urging first-degree murder and not just a life sentence, but the death sentence. Evan, any insights about this one?
Yeah, I mean, these are all very, very sad cases. And one thought that I would have about this would be a reminder to the authorities who are investigating crimes. I'm sure that most detectives and investigators in most police departments are very thorough, to check all of these sources, this electronically stored information in the voicemail. So if anything, it's a reminder of all the, remote places that evidence for a crime can be found, not just, in where the yellow crime scene tape is.
Yeah, absolutely. Erik, how about this notion that our phones can sort of, I don't know about you, but I have had my phone kick on and start dialing somebody, when it has not been in my pocket, when it has not been in contact with anything else. It's almost like, it's Watson again, deciding that it's going to use its free time to manipulate our technology. What do you think about the impact of this on society?
Yeah, and I think there's even a Facebook group for I feel my phone ringing, but it's not actually ringing, sort of thing.
Yeah.
I mean, it's just another one of the risks of technology. There was a digest in the early '90s called the Risks Digest that talked about this particular thing and the risks of technology and the sorts of things that can happen. As I read this story in the TampaBay.com website, what struck me, besides sort of the the luck that they had in discovering this information was, how easy would this sort of thing be to fake, and how easy would it be to set somebody up with a recording? Because our voices are all being recorded right now. It would be relatively easy to patch together pieces of voice and and plant a recording. That would make a really good movie.
Yeah, that sort of combines our last story with this one. Someone trying to doctor up evidence or try and cover their tracks could use a mistaken voicemail to, could create one.
Yeah, absolutely.
Given enough technological tools. So given that, Kevin, do you think that all the forensic folks who help out during trial are prepared to deal with the various manipulations that technology can enable?
Having known some forensic people, I can certainly say that, given the right set of clues that they need to look for that, I think that certainly is something that they can handle. In here, I think they're able to go to the provider and get a clear copy of the cell message from the cell phone company. But beyond that, otherwise, you're into some other potential context could be a case in which somebody is accused of saying something and it's doctored up, to make it sound bad for the political candidate or something like that, some sort of a smear campaign. And at that point, then it's in my particular hypothetical, I think it would certainly depend on whether or not they reasonably could figure all that out, as to whether or not this had been put together from multiple separate recordings.
Well, I think all our TWiT audio engineers probably, could make a little money on the side by offering up their expertise.
I'm sure, too.
Evaluating the legitimacy of various recordings and whether they've been doctored up or not. Sybil in IRC. Yes, I'm getting $ in the Skype chat back at me from Burke in the studio. Or maybe that was John. Anyway, Sybil in IRC says, this makes gives the hacker's man-in-the-middle attack a whole new meaning. I'm not sure I know what the man-in-the-middle attack is, but for those of you who do, I'm sure that's a pithy observation. Anyone know what Sybil is referring to with that?
I'm not sure exactly in this particular context.
Little deer in the headlights. All the hackers can come get us with that now because we don't know what it is.
Well, I know what a man-in-the-middle attack is, but exactly its reference to this particular context is another matter.
All right. Well, educate us so that we're equipped.
Well, a man-in-the-middle attack is somebody like you're at the Starbucks and you connect to what you think is the Starbucks Wi-Fi, but it turns out to be the guy in the corner, and he acts as the man in the middle, and relays your requests on, and you think you are connecting out properly in a secure fashion, but in all reality, the man in the middle is capturing everything that goes on in your particular transaction.
Got it. Okay. I just never heard that. I've heard of obviously that situation, but not heard of it.
I was thinking about Michael Jackson's Man in the Mirror.
Security Now.
Right.
The man in the mirror in the middle. All right. Well, someone who was in the mirror at home, perhaps, when they were busy communicating with their fellow ambulance employees. This is something we've talked about on the show a couple of times. There were some activities going on for this ambulance company where their employees were using Facebook to communicate with each other off hours and using their own technology. One of the employees was fired, and the company cited the company's blogging policy or online communication policy as the basis for this, because you weren't supposed to badmouth the company per that policy in any sort of online way. The NRLB, the National Labor Relations Board, got involved and said this kind of a restrictive policy, we fear, violates the protections that are in place for employees to be able to organize and unionize, et cetera. And so this was coming down the pike for a decision by the NLRB, and the parties settled. So that's just sort of the update in this case, that has been settled. There's no disclosure about what the terms of the settlement were, but it means that we're not going to get a definitive statement from the NLRB about this. But it's interesting in any event that they got involved and that they raised a red flag about this kind of activity. And it certainly gave an opportunity to a lot of employment lawyers to send out a whole round of alerts and warnings to their clients that they've got to review their blogging and communications policies to make sure that they're not inadvertently treading on their employees' rights as far as what the labor laws provide and require. Evan, we've been through this. Do you have any thoughts now that the case has settled? And are you surprised that the parties worked this out on their own?
No, I talked to some labor and employment lawyers here at my firm about this, and most matters in this procedural posture do settle. So that it's no surprise, or certainly not an anomaly, that it did settle. And so I don't think there's really too much new under the sun in all of this, other than it being kind of an indication of a certain telegraphing of what the NLRB thinks about all of this. And so perhaps from a policy standpoint, by doing this, they're just kind of putting the issue out there so that employers can take notice, do some things about this, recognize that these types of communications can present real issues, and so maybe there is a real pragmatic purpose to all of those alerts that lawyers would send out in response to all this. All these, click here to download a PDF copy of our most recent alert
newsletter
type of things.
Yes.
Yes,
exactly. Don't
you love those?
So here's an update on Man in the Middle from Sybil and JD Ankanian in IRC. What Sybil had in mind is that the Man in the Middle would become more proactive, not instead of just intercepting the data, would actually insert messages and fake them. And the additional comment there is that corporations may be engaged in paying hackers large sums of money to do this in sort of a corporate espionage kind of way. Mm-hmm. And, the danger is the government might be able to do this kind of thing as well. So, it is a concern and scary when you think about, how it happens without paying money to hackers, just, from the technology itself, kind of taking things into its own hands. And the labor case, the ambulance case, Erik, are you thinking that there's a mad scramble to adopt policies so that it's clear that what this leaves open is if you're using corporate assets on corporate time and maybe disclosing confidential information, I think it would be a different kind of outcome than if you're off hours complaining about the company. Is that your impression too?
Yeah, and I think that's sort of the general rule is, you use, whether it's complaining stuff that you're doing or in the context of what I do, creating intellectual property. If you're going to be doing that, do it on your own time, use your own computers, and the same probably applies to commentary and criticism. I think the thing that bothers me about all of these cases is, what is it with employers and whatnot? They got way too much spare time on their hands. Let people have an opinion, for Pete's sakes. I don't know if you saw the infographic that I tagged from Mashable, but it's really depressing, sort of the level of you can't call it censorship if it's done by a commercial entity, but the degree to which the thought police are alive and well in 2011 in this country is, I think, embarrassing. On that infographic showing where internet censorship is in the world on a colored map, with the far left being no censorship and the far right being pervasive censorship. The U.S. is sort of left of center. We're in the some censorship category, and why is that? Why are we not in the no censorship category? That's one of the things that bothers me.
I think from the commercial or the corporate standpoint, it's all fear. There's always this concern that there's going to be some kind of lack of control or loss of control. So I think it's as simple as that, just wanting to keep people under their thumbs so that you subject their will a certain way.
Kevin, any thoughts on this one? Censorship related or otherwise?
Not much more than what Erik and Evan have already said. It's you always see that when some companies getting online for the first time, they get really restrictive social media policies, and this is just simply one more analysis of it. I think the good that came out of this particular case was that this particular employee agreed as part of the settlement to revise the rules to be less restrictive. I've always gotten a lot of good mileage out of the Clue Train Manifesto and other seminal works in social media. And number one rule is just simply to be authentic. Be yourself, be human. Even a corporate, even though they're not necessarily human, is act human-like, and that's by having a human face in your conversations.
Yep, always good advice, and we love invoking the Clue Train Manifesto whenever possible. It's sort of the Bible of online communications. So this next story sort of violates that Bible, I think, a bit, at least for me, from an annoyance standpoint. Everyone know about Paperly? Everyone been impacted? Paper.li. By having that show up in your Twitter stream. And the way it shows up for people is you see them as ats when somebody has included you. And Erik, since you sent this to us, why don't you describe for anyone who hasn't seen Paperly or been annoyed by it, how it actually works, because I don't use it. It just sort of came my way, and then I blocked it, and I haven't seen it since. So tell us what it is and how it works.
Well, sort of to make an analogy, if you remember, what sort of like a My Yahoo page or a My Google, whatever My Google calls that, or in the Twitter world, if you're using something like TweetDeck, it's a once daily web-based newspaper-like interface of the people that you follow on Twitter, and sort of presents a nice summary. So if you're not the type of person, I think like all of us on the podcast today who check their social networks multiple times per day, it might be nice for you to have a single place to go and do that. And ostensibly that's what Paper.li, I have no idea how to pronounce it. Ostensibly that's what they do. But the thing where it differs from something like My Yahoo or a TweetDeck is that this interface is public facing, and furthermore, obviously built into it by default are these auto tweet mechanisms. So
yeah, that's the issue, huh? Aggregating content from someone you like, as John is pointing out in Engineer John from Twit is pointing out in the chat room. Apparently, he's following Colleen, formerly of Twit, now of Google, and getting the information that she has put together every day, and that it's great and useful, and that's just fine. But the business model here has been to alert people of its existence by, if you are featured in somebody's Paperly, sending them an @ and it's very. I think there's a way that they could have done it that wouldn't have been quite so heavy-handed, if it wasn't just a bot, if it was somehow more personalized, it might. And
I think featured might even be too strong of a word. I think, mentioned, it would even be generous. In many instances, when I get a notification that, hey, you've been mentioned in the Spam Bot Daily or whatever it is, right. I haven't blogged anything or tweeted anything of significance in the previous 24 hours, and yet there it is showing up. And all it does to my stream is add noise and not add signal. And I've worked very hard to keep the signal to noise ratio high in my stream. So I've taken to calling people on it publicly, and going so far as to say you should unfollow this person because they're using spam service Paper.li, and then blocking them and anybody who retweets it.
Well, let's talk about the legalities of a service like this. This service strikes me as kind of this layer of site that seems to be more and more common on the web these days, the eHow kind of universe, where it's aggregating a bunch of content from different sources. And sure, it might be useful, but it's not, the most definitive or the most deeply delving kind of information source. It's, they're being established because it's a good way to manipulate search and appear high in search results and make money. And I assume that part of that is part of Paperly's business model in doing this. So there are a couple of legal concerns that I could see. One would be the aggregation question. Obviously, when you're pointing to other sites in just a link fashion, that's one thing. But when you're aggregating and using a good deal or maybe all of the material that's being pointed to, then you have copyright issues. And then also there's this name and likeness issue, a right of publicity issue. It sort of appears to someone who's not real familiar with what's going on here technologically that the people within a Paperly page are a part of that organization, or, you know, writing for them or endorsing what they're doing, and really they're just being pulled in through automated means. Erik, thoughts on the legalities?
Yeah, no, I think they've definitely got an issue there again, because it's one thing if you're doing it on a private-facing thing like iGoogle or My Yahoo or a TweetDeck. I think it's another thing entirely when it's public-facing, like the paper.li or however the heck you pronounce it.
Exactly.
It does. But again, you know, I don't really care so much about the fact that my social media content is distributed and aggregated. I sort of expect that. You know, what I don't expect is to be spammed by all these different dailies, and it's not just once or twice a day. It's multiple times per day, and it reminds me of the first iteration of Plaxo when it came out. And you were getting dozens of emails saying, "Hey, I'm updating my address book," and it was, and people, you know, reacted negatively to that as well as they should, because it just turned into a spamming service, and B, self-publicity. And that's what I see. The main purpose behind these auto tweets is for paper.li to be publicizing itself, and that's the definition of spam.
Right. Anyone want to take the counterpoint that this is just another aggregation service and maybe they're a little aggressive in their marketing? Kevin?
Oh, sure. Go ahead. Put me in that role. You know, my personal take is a little more along Erik's lines. But, you know, they certainly are, you know, able to go out and, you know, post that they have new content, and, you know, they can certainly post, aggregate themselves. Geez, that's a really hard position for me to take, is, you know, pro spam. All I'd say is it's certainly something that people, when they signed up for Paperly, they opted into this system. I think they can opt out. I think you can have your own Paperly newspaper without auto spamming. I would certainly encourage people to do that, to turn off the auto notification feature, not only for this, but just in general. I think of Twitter as something to have a conversation with people about. It's certainly not a place where, you know, I would expect people to go and you know, get auto-fed content. To get another place to get spam. I get enough spam on my inbox. I don't need it in Twitter either.
Right. Well, I certainly violate that, because I use Friendfeed to route things into Twitter from my other activities. But I'm not, you know, @ing people necessarily, or when I do, I'm doing it as in a way to give credit. You know, as I go through and prepare for the show, for example, I'm bookmarking things in Delicious, and those get fed into Twitter so people can see, if they're interested, if they're following me, they don't have to follow me, what we're going to talk about on the next week's show. So although that's an automated kind of thing, I would distinguish that from what's going on here. Evan, what do you think about this whole layer of the web that is developing to sort of leverage search and try and grab people's attention through search results?
To me, that seems like something that is good about the architecture of the web now and the sensibilities and the norms that are there. I put it under the heading of curation and community building, you know, and those are concepts that, you know, have been floating around quite a bit in the last couple of years, particularly as, you know, this stage of Web 2.0, you know, all of that stuff, all those buzzwords and stuff like that. And so, you know, there is a certain, you know, from a certain perspective that can be irritating, and, you know, using that sort of glomming onto information that way and using it for self-serving purposes can be irritating and spammy and all of that stuff. Looking at Paperly, and I know this is a little bit different than the particular question that you've posed to me here, but I'm not concerned in most instances when there is stuff like Paperly that comes out, because I recognize at the foundation of it these notions of curation and community building and kind of making content something around which we can have a community to be good things. Those are good things. It's just when it is not well executed that it becomes irritating. At the same time, when it's not well executed, that usually means that it's not going to have much evolutionary success as it goes forward. If it's irritating and spammy or whatever, people aren't going to pay much attention to it, and it's going to die off. With Paperly, I see myself mentioned in Twitter feeds. I at first I was puzzled. What is this? I click through. I see kind of a really ugly layout. And so I quickly lose interest, and I trust that if I'm developing that impression of it, then others may be as well. So, leveraging a certain layer of stuff on the web can be good in most instances. I'm not going to get too worried about the legalities of it all, just because I think we should be more liberal in our notions about these things. It's just, if it's not well executed, let's not worry about it.
Mm-hmm. It may just die its own death if enough people dislike the way it's being rolled out.
Yeah.
Yeah. Well, something
sooner the better.
Yes. Something that does not react too well or really change its attitude too much based on public likes or dislikes is the National Security Association and what goes on under the Patriot Act. Evan, we talked about gag orders a couple of episodes ago. And let's see, who was our friend on Twitter who tipped me to this? JCS3 on Twitter said, check out this On the Media story. And it was fascinating. It's in our show notes at delicious.com/thisweekinlaw/99. Links to everything we're talking about today are there. And this is the full transcript of a segment called National Security Letters and Gag Orders from the excellent On the Media show from NPR. And it is very illuminating as to this technique, procedure that the NSA uses. It serves these national security letters asking for information, in this case on an ISP. I guess the Internet Archive has famously received one, but very, very few of them, maybe just these two, have become public, even though hundreds of thousands of them have been doled out over the years. About 50,000 of them served on people per year. And what they are these super secret requests for information, and they include in them language that says not only must you comply, but you cannot tell anybody that you have received this request. It doesn't elaborate on that. It just says tell no one. This particular person, Nicholas Merrill, who was interviewed here and is the founder of the Calyx Internet Access Corporation and the Calyx Institute that is attempting to shed some light on this procedure. He did not listen to the stricture and consulted a lawyer and got civil rights attorneys involved and was off to the races, hence the interview. But it's all very interesting, especially the volume of these that get served. Evan, any thoughts in light of our previous gag order discussion?
Yeah, I mean, I am mindful to always keep the overall analysis in the real context of understanding that it's important for investigations to be done in secrecy at times. Mm-hmm. But if there are 200,000 of these things going out in the course of a 3-year period, that is too much. It's really getting Orwellian at that point. And my concern, just based on the pure volume of this, is that is overreaching. Each one of those cannot be legitimate trails of Al-Qaeda, or whatever. Mm-hmm. So it really, it gets frightening to me when I hear that there are numbers like that, because that is just really Gestapo kind of stuff that is gotten out of hand.
Right. Kevin, have you ever encountered one of these things? And what would you do if a client came to you and said, I've gotten this super secret letter?
Yeah, goodness. I can honestly say I haven't personally received one, but even if I did, I don't think I'd be able to tell you.
Yeah, you wouldn't be able to talk.
I agree with Evan. I think it's there's a lot of the Patriot Act that's been written for the point of view of government and its role in protecting people at the expense of liberties. And this is certainly one of them. And if they certainly have been used as much as they have, over 190,000 is the last count, then certainly then they're being overused.
Yeah, it's. I was reading the story and prepping for the show against the backdrop of listening to Secretary of State Clinton's speech about internet freedom and her point about how we, make this balance between security and openness and the security measures. Here in the U.S., we can feel good about the fact that the security measures all are subject to the rule of law and appeal. But I think this is the kind of example of a thing that really isn't. Erik, any thoughts?
Oh, I think that the worst thing about the Patriot Act is its name. I think it is unpatriotic, and I think what we end up with as a result of all this is not actual improved security, but what we get is security theater. Whether it's being put on by the performers at the NSA or the TSA or ICE. There's far too many stories, and frankly, to echo what other folks have said, it sounds like a story that's coming from another country in another time. It doesn't sound like a story that's coming from the United States in 2011. So I hope in my lifetime we see the repeal of the Patriot Act, but I'm not holding my breath.
All right. Well, the other folks not holding their breaths are the MPAA, their latest target, having, had the RIAA go after sites like Grokster some years ago. Seems that the lockering sites out there are coming under fire now because it's easy to upload and share files that way. As an alternative to P2P, we saw RapidShare have litigation a few months back. Now we've got Hotfile, and they're particularly in the sites here because they apparently have an incentive program in place where, if you're getting a lot of downloads from the material that you're sharing through their system, then I'm not sure if I think you get paid or you get some sort of reward for doing that. So they point to that to say, the only way you're going to be able to really exploit that incentive program is to upload copyrighted material. That's a bit of a leap, don't you think, Kevin?
Well, I'm sorry. I was actually looking down at my notes when you asked me the question. Can you repeat the question?
Sure. I'm saying that the MPAA is sort of making the assumption that if you're going to be compensated, the incentives are in place to have you share material that's going to be downloaded a lot, that of course you're going to be uploading unlicensed, unauthorized, copyrighted material to take advantage of those incentives. Yeah. And so that something like Hotfile in particular, because they have this kind of a measure in step, that they're going to be subject to being pulled down, under the same reasoning as Grokster was a few years back. Do you buy that? I think there's a lot of opportunity to share things that would have, a lot of traction that would not be something the MPAA should be concerned about.
Well, I think there are certainly files that could have over 1,000 downloads that would be free from concern from the MPAA. That's certainly true. But if you look at things like Hollywood movies, if they're being shared on that particular file, that certainly would be an easy win, and an easy way for somebody using that system to get money would be to regularly upload things where you can get lots and lots and lots of money from Hotfile. And so I can certainly see the allegation. Whether that is true, I think would only come out during discovery when they get the company to turn over records over just which files did you actually pay out for. But it's certainly a headline leading claim made in their complaint, that's for sure.
Yeah. Well, Evan, we're getting into this world of cloud computing and everybody wanting to be able to have things out there and available to share and download. There are tons and tons of sites that facilitate that these days. It's a very viable business model for folks. Do you think that that's going to go away because the MPAA is looking at them as the next wave of P2P?
No, of course not. And I don't think the MPAA is going to see much success in this case against Hotfile. I mean, I'm really surprised that they're doing it, especially with the lack of success that Viacom had with YouTube. If you go to the Hotfile site, it certainly appears to be legitimate. I trust that it is legitimate. There's nothing, flashy. There's no it doesn't use the HTML blink tag or anything like that. So it's very much all DMCA. Very much it has the DMCA front and center. If you right there on the home page. You click on, the intellectual property policy, and it's, the first thing out of their mouth is, we are a service provider under the Digital Millennium Copyright Act. And so, given the, the analysis that we got from the court in the YouTube Viacom case, that provides a lot of protection. And, even if there is, going to this whole notion of making money off of the users making money off of all of this stuff, it has to be a lot more for, going on there. Then it has to be more than that to satisfy that Grokster inducement level, because in Grokster, as we've discussed before, that was very much based on the facts of how they were marketing the stuff. I just don't see it here. So to think that this could somehow chill the entire fundamental way that we are thinking about computing these days, being in the cloud. I just even hate saying that anymore. It's almost become so, it's not cliche, but you know what I mean? There's the advent of cloud computing and all that stuff.
Sure.
There's no reason to think that something like this, a challenge by the MPAA, is going to diminish that progress at all.
Right. Erik, any different take on this? Or are you right in line with Evan?
No, I agree. I don't think the MPAA is going to be able to sue itself into profitability or relevancy, and I think that they've been trying to do this along with the RIAA for years. I did look at the Hotfile site. I didn't see anything about incentives. Maybe they do offer incentives. That's probably a bad idea if they did offer them. But just because there is incentives doesn't mean that there is copying. But again, the bigger issue is, does it matter if all this copying is going on? Does it matter? Broadcast television and broadcast radio put content on the airwaves for free, and have been doing that for decades, and there isn't any evidence that is hurting sales. It acts as marketing that helps sales. And the leap that the MPAA and the RIAA would have us make is that every single copy that's out there represents a lost sale, and it's simply not true. And I don't know how many more years it's going to take for them to figure it out that it's not true. But what the MPAA and the RIAA need is they need new leadership, and they need a new business model. And they needed it 15 years ago, because we're half a generation into it, and they still haven't figured it out.
All righty. Well, with that, I think it's time to move to our tip of the week. And our tip of the week this week is, if you are someone whose ethics are very much bound up with your job description, such as a judge or a teacher, and I'm sure we could come up with other examples, your approach towards social media has to be completely different than somebody else's, average run-of-the-mill person. And I question whether that's a good thing or a bad thing on a societal basis, but it's just a reality. And this tip flows from the fact that there was a teacher whose private Facebook page, I saw the story on CBS, the excellent CBS Sunday Morning Show, whose private Facebook page had some pictures of her traveling in Europe. And who knows, she must have been in Germany or some such place. And in one hand, she had a mug of beer. And in the other hand, she had a glass of wine and a big smile on her face. And, she's just off on her summer travel somewhere. And this was, she had very properly locked down her Facebook settings so that only her trusted friends could see her photographs and postings and things. But it's just an object lesson in the fact that even when that is the case, one of the people that she had actually approved to see this material must have shared it with somebody who was not, and her school district, her principal, got an anonymous letter saying, your school has a very strict policy about what teachers should or should not be putting online and the image they should present, and here's what this teacher did, and she was fired. And, she's looking into legal action about all that and what have you. But the fact is, it's some very dangerous ground out there if you're someone whose public image is subject to attack quite so easily. Any quick thoughts about this story before we move on to our resource of the week, Evan?
It's just unfortunate to see school administrators overreaching, which is what they did here. The societal norms in that community, I think, just didn't really mesh up with what this gal wanted to do and what she was perfectly entitled to do.
Right. So for all the details on that, do go to our show notes. I'm just sort of glossing over that one very quickly here at the end of the show. And I do want to get to our resource of the week because it's pretty interesting, an interesting use of the web. It is TWiL, or TRUVELI, TRUVELI.org. It is for lack of a better term, crowdsourced dispute resolution, online crowdsourced dispute resolution. So what they're doing is sort of disintermediating the entire legal system, as a lot of private judging and private dispute resolution does. But this model struck me as pretty interesting because what they do is they get people from all over the world to sign up to act as judge or jurors on their site. And if you have a dispute with someone and everybody agrees, you can go there and have these disinterested parties, not from your community, resolve your dispute in a binding way. And they have an escrow function so that, if there's money at stake, the money can be escrowed and then distributed out by the site to the party who wins the dispute. So it's pretty interesting. I've never seen anything quite like this. And I encourage you to check out TRUVELI.org. And with that, we're going to wrap up this episode of This Week in Law. Thanks so much, Kevin Thompson, for joining us again.
Well, thank you, Denise. It's always a pleasure to be on.
Folks, you can find Kevin at cyberlawcentral.com, and he is Cyberlaw on Twitter. We'll see you again soon, I hope.
Thank you.
Also, Erik, wonderful to chat with you again for an hour this morning.
Thanks, Denise. Glad to be here. Go Sox.
Go Sox. Yes, lean to one side so we can see your hat.
There it is.
There it is.
And I got the winter one here too. There we go.
There we go. So Erik is Erik J. Heels on Twitter and erikjheels.com. And obviously we will be watching the baseball season with great anticipation.
100 wins.
Yes. And Evan Brown, thanks so much for joining us again.
Hey, thanks for having me. Wonderful time. Always good to talk with my buddies Erik and Kevin. Good to participate here.
Nice to chat.
Yes.
That's wonderful. And folks, go find Evan at internetcases.com and internetcases on Twitter, where he always has good 3-character self-identifying things to contribute to the discourse.
Yes, and, always up for concision.
Yes. And thanks so much for joining us again for This Week in Law. And if you're listening live, very shortly, we're going to go right into our 100th episode of TWiL. So if you are a fan or listening for the first time, we do record live on Fridays at 11 o'clock Pacific, 1900 UTC at live.twit.tv. join us there. And between the shows, visit our Facebook page at facebook.com/thisweekinlaw, where we post pre-show questions and love getting your feedback on the things that we're going to talk about. Thanks, everyone. Take care.
Thanks, Denise.
Bye-bye.